everybody for joining us today. It's always such a pleasure to be able to present to the members of CARP. So today we're going to be talking about empower your legacy and specifically how to safeguard your wealth, minimize taxes, and ease the burden on loved ones. We have a lot of different stories to share with you about that. In general, I'm Ellie Muir. I am an estate solutions advisor here at ClearEstate. I'm one of the people that first meets with people when they approach ClearEstate for assistance with estate planning or estate settlement. ClearEstate has been helping people for a few years now. We've been around since 2020. We currently have, just in 2023 alone, signed up over 500 people for our estate planning services, and we look forward to telling you more about what we do. Our platform is very much tech forward, but we have a really human-centered approach when we help our clients through the estate settlement and planning process. And today specifically, we want to tell you a bit more about our professional executor services and things to think about in terms of whether or not it's a service that you should consider for your own estate plan. So I'll pass it along now to Carrie Abma, introduced earlier by Carrie, our other Carrie, and she's going to take it from here.
Great. Thanks, Ellie. And thanks, Carrie, for the warm introduction. And as Ellie said, so happy to be here and to have you all with us. You probably, well, none of you recognize me. This is my first webinar with CARP. But as Ellie said, I'm Carrie Abma. I'm manager of professional executor solutions here at ClearEstate. Certified TEP, over 10 years of experience in the industry, been with the ClearEstate since June 2021. I love the industry. I love educating folks like you on, there's so much to know and it can be overwhelming and daunting, but it's really important that we share this information with you so that more people can have really good estate plans so that when they do pass away years and years from now, things go as well as possible for the family. There's lots you can do now to make sure that things go smoothly. So we're here today to kind of share with you several stories, kind of case study like format. And we're going to kind of do it in 3 buckets. So we'll look at the learning outcomes here for you. So we're going to look at estate planning strategies. The 3 main areas are going to be financial, liability and kind of burden on the family, and then complexities. So hopefully you'll find it informative, educational, and we will have the Q&A at the end like Carrie alluded to. So feel free to drop your questions in there along the way, and we'll get to as many of them as we can at the end. Okay, so just a quick overview of estate planning can be very complex and time consuming. It's very detailed. You know, you need to kind of think about every little thing that could, all your assets and every kind of situation, and you got to do your best to plan for that. So it can be very detailed. Legal documents. A lot of people are afraid of legal documents. In planning, there's a few that you need to kind of consider and prepare and select the ones that are right for you. And then, of course, on the settlement side, there's legal documents that come into play at that point as well. Multidisciplinary knowledge. So there's lots of kind of complexities or areas that you can kind of dive into, such as corporations, foreign assets. So lots of areas to kind of specialize in, farm properties. So it is good to have kind of a multidisciplinary team that can help. Taxes is another one, of course. And a view of all assets and liabilities. This can be really helpful to kind of see it in front of you, kind of in a picture form or in a diagram, or so that you can really see how everything fits together and what the end result will be. So we do find that's helpful. Beneficiary needs and dynamics. So this is also very important. Not only the family dynamics now, but also what their needs might be when you pass away and how you can best set things up for them. And then fiduciary duties. So this is a very kind of legal term, which means acting on someone's best behalf. So in the estate planning area, it's your executor will be acting on behalf of your estate and in turn for your beneficiaries. So that's a very kind of role to be taken seriously. Understand what that means before you kind of dive in. So hopefully today will help you on the planning side understand more what that means so that you can make the right choices for you and your family. Excuse me. So one other thing I'll mention here on this slide quickly is just to make sure that your planning is personalized for your needs. So what worked for your neighbor or your friend may not work for you. So it's important to kind of gather all the information and then make the decisions that make the most sense for you, what your wishes are and your family. And with the end result of leaving the legacy that you intend. So we're going to start with the case studies, the first one being financial savings. Okay, so beneficiary designations. So very important to keep beneficiary designations up to date. So in this case, the widow wants her estate to go to her only child. She didn't update her registered account beneficiary designation after her husband passed away. So what happens there is that there's no living named beneficiary on the account, and it defaults to the estate and therefore becomes subject to probate tax. So those probate taxes could have been reduced had she updated her documents and named her child rather than leaving it with her predeceased husband on there. So very important after any material change, of course, one of the very big ones being the loss of a spouse, is to update all your documents and make sure that they all align with each other and with your wishes. The next one, joint accounts. This one we hear about often. In this case, we're looking at a situation where we could have avoided double probate tax. So the couple holds individual investment accounts. On the first spouse's death, the account forms part of their estate and passes to the second spouse according to the will, and then subject to those probate taxes. On the second spouse's death, the same account is then subject to those taxes again when they pass away. So probate fees could have only applied once instead of twice. If your intentions are that the account is to pass directly to your spouse, it may be a good idea to have that held jointly between both of you. And that way, when first passes away, it just automatically, it actually stays the same. That person's simply removed and it stays in the name of the living spouse. And then it does not go through the estate. So that's a really good one to keep in mind. Probate exemptions. Always great to make the most of any available exemptions. Of course, it's very hard to know what they all are, which is why it's good to consult professionals. So in this case, we have a single senior in Ontario who owned his house for 50 plus years. His property therefore qualified for the first dealings exemption, which means that it waives probate because it's considered the first transfer on the system, on the land title system. So with the use of a secondary will, a strategy that can be often implemented in a variety of cases, and this one particularly well, where the primary residence, the property, could have avoided probate tax. But if you don't know what you don't know to ask. So it is very good to have people you that can look at your situation and provide this information for you. So here, the impact of probate could have been drastically reduced. If the exemption is available, it's great to know what to put in place in order to take advantage of those. So proper planning here with a secondary will would have gone a long way. Spousal rollover. So I'm sure all of you like to see this little catchphrase, don't pay the tax man until you have to. So in this case, we have a widow who inherits her husband's estate. She's acting as executor. She proceeds to liquidate all the investments. What she didn't realize was she, as the spouse, has access to what's called a spousal rollover, and she can transfer assets in kind at her husband's original cost base, and that defers the triggering of any capital gains until she passes away. So in this case, not only does it defer tax, but it could also potentially reduce the tax if during the lifetime of the surviving spouse, those funds are depleted, right, to care for her cost of living. So that the value of the account could be lower by the time she passes away. So some good things to know here with the spousal rollover. Joint real property. So we see this all the time. Questions are asked about this very often. And here, what we're going to talk about is the risk involved in joining your real property, so that you're aware of what they are. So here we have a widow who adds her son as joint owner of her house in order to avoid probate. Little does she know that her son has financial issues and owes a significant amount to creditors. So when he runs out of his own money to pay his debts, the creditors come after her house because it's half of it is in his name. So in this case, sounds like great planning for when the time comes that her estate will be settled. However, during her lifetime, she runs into challenges with this setup based on her son's financial situation. This is also something to note if your child owns a business, because that can be another time where creditors may become involved. So lots to think about here. And again, like, it's not always about the probate savings. So sometimes the risks can outweigh the benefits. And again, it goes back to understanding what those are so that you can make the right choice. On this slide here, we're going to talk about the same thing, but a different implication of joint real property. So here, we're talking about tax implications. And in this case study, we're looking at trading one tax for another. Same situation, the widow adds her son as joint owner to avoid probate. However, her son has a principal residence of his own, which is often the case. This impacts her access to the principal residence exemption. What happens is what she would have saved in probate fees is far outweighed by the gains that she would have been exempt from on death. So again, not always about probate savings. 1.5% is kind of small compared to what a capital gains tax might be, depending on how long you owned your house. So again, a lot of people are focused on that one thing, but it's really important to look at the big picture and step back and weigh out the risks and the benefits. Okay, charitable intentions. So what we want to see is many people take advantage of the charitable tax credits as possible. There's lots of generous folks out there, and you might as well take advantage of the credits available to you if you're in a position to be able to donate on death. So in this case, we have a regular generous donor to various causes, and he's thinking about charitable gifts in his will, but never gets around to planning for this, unfortunately. His substantial registered and non-registered investments have significant tax liabilities when he passes away, and he loses additional tax efficiency that could have been available if he had done something like an in-kind donation. So again, it's very important to know what's available to you. So he could have left his estate with more money while still donating to those charities. So significant tax efficiencies can be accessed. For example, one of the things that's available is you can increase your donation limit on death to 100% of net income. Okay, part 2, we're going to look at case studies that are around kind of liability for the executor and burden on the executor. So obviously, when we're dealing with loss, there's a lot to deal with. And the role of executor can be kind of just added to that. And there's varying degrees and situations where this can be avoided. There's lots of strategies and ways to set things up to keep this in mind. So we're going to start with the default executor. So here we have, it's kind of a story of making sure you're selecting that executor wisely. So we've got a testator. For those that don't know that term, it's the person who's writing their will, and they select their oldest child as the executor because it feels like the right thing to do. In this situation, the eldest child is, however, not financially savvy and doesn't have a great relationship with one of the siblings. She has a lot of difficulty navigating the settlement process and feels pressure from her sibling. Unfortunately, this has had significant impact on her mental health and the estate settlement process in general. So in this case, the right executor could have been chosen. So there's lots to think about. And again, it's what's right for you and your family. But like I said at the outset, what worked for your neighbor or your cousin or your friend of a friend doesn't necessarily mean it'll work for your family. So again, understanding what's involved so that you can choose correctly for your situation. And keeping your loved ones in mind, obviously, the role of executor is a big one. So lots to, it feels like an honor, but it comes with a lot of other things. So it's definitely something to really consider. Our next case study involves multiple executors. So too many cooks in the kitchen. So in this case, a mother doesn't want to appear as though she's choosing a favorite. So she appoints all three of her children as executors. We see this often as well. It is hard to maybe pick one or two if there are more than two children, but it really can make things go smoother. So in this case, the kids, they have varying levels of interest and aptitude for fulfilling the duties. Fighting ensues, causes delays and strain on the relationships between the family members. So even if your children get along, we've seen it before, grief, the process can really add to the relationship strain, and families that got along well. Once that kind of glue that holds everyone together passes away, we sometimes, not all the time, but sometimes see kind of a breakdown in those relationships, unfortunately. So another thing you can do is speak to your children. So we do recommend that, and maybe they'll voice that they don't want to do it, and they're okay with letting someone else do it. So that can help as well. Delays and strain can be relieved with fewer executors, even if they get along. Just leads to quicker decisions, and the estate can kind of move through the process more quickly and efficiently. So time constraints. So you hear people say it all the time. There's just not enough hours in the day. So imagine adding the duty of estate settlement onto your loved ones. So in this case, we have a dad who feels that his youngest child is actually the most appropriate because he's a successful finance professional. So he wants to put him in the role of executor. In this situation, though, the son has young kids, a very demanding job, and has actually never dealt with estate settlement before. So all of those things together make it very quickly an unmanageable burden on that loved one. So it's very important to think about how, your chosen executor's lifestyle. And of course, that could change as well. Something else to think about that could change by the time you pass away. But to just think about, do they actually have the time? Maybe they have the knowledge, but do they have the time? And so it is very time consuming. It can take several hundreds of hours over a kind of a 12 to 18 month period to settle an estate. So again, good to know that. And have a contingency plan as well. So you can always have a backup executor or executors listed so that when the time comes, if this child at the time that you plan is comfortable and okay, but by the time you pass away, maybe things have changed and they're not able to, you have someone else in place instead of it having to be chosen by whoever's left to decide who's best in that role. You can decide. Personal effects. So this is one of my favorites. This can be, can cause a lot of issues, and it's really sad to see. And again, with the proper planning, a lot of that can be avoided. So mismanaged personal effects. In this case study, we have a widow. She dies living in the home where she and her husband spent the last 40 years of their life together. So lots of memories, lots of accumulation of things, and likely the family spent some time there as well. Memories. Unfortunately, she doesn't know to provide specific instructions in her will or a supplementary document that specifies what she would like to do with those items. So in this case, her 3 children are left to decide what to do, and disputes ensue over sentimental items. So this is often something that gets forgotten about because it doesn't come with a lot of monetary value. In fact, personal effects are usually valued at much less than people expect. But there's a lot of sentimental value. So, and that's like, it's hard to put a value on that, right? So people often have trouble deciding how to deal with these items. So things can be done in advance. One thing is you can put wishes in your will. There's also a memorandum that can be prepared and attached to your will or kept with your will. Now, that's not a legally binding document. However, I mean, your executors has it, and I don't know why they wouldn't follow it. It's your wishes in writing. And so it really can help guide. And I think too, when family members see that the testator has put down in writing what they wanted, they're often much more amenable to following those wishes. Okay, and then we have estranged siblings. So oftentimes there's, some strain in the relationships at the planning stage. So it's good to obviously acknowledge that and try to plan for that as well. Oftentimes that doesn't go away with the death of a parent. So in this case, we have a mother who knows that her two kids don't get along. She appoints her two friends as her executors, but she doesn't discuss it with them. When the time comes, knowing the family dynamics, the friends actually receive advice not to take on the executor role, likely because it could involve some legal action, some litigation, them having to kind of manage the siblings' relationship, which comes with a lot of additional burden. So in this case, the kids are left battling over who will be executor, obviously not wanting to work together, but also not wanting to allow the other sibling to do it without them. And this kind of things can be at a standstill in this situation. So what we want to know here is that a professional could likely have foreseen this outcome. With the proper advice, the mother could have been prepared for the fact that her friends may not want to act. So she either could have chosen an alternate, or she could have, again, had that contingency plan in place as well. She did think about the fact that probably not wise to appoint her daughters, which was probably a good thing. But so she thought she was doing a good thing, but she didn't kind of think about that possibility, or didn't know to think about that possibility. Joint bank accounts. Okay, so joint isn't always better. So we hear about this one all the time as well. Banks often recommend it, and there are obviously very good reasons to have this set up, but it's important to understand what it means when you pass away. So in this case, we've got an aging dad. He adds his youngest child to his bank account since he will assist him with bill payments, etc. As it becomes harder for him to do it himself. So when he passes away, the bank tells his son that the account is now his, and he accepts this. The siblings decide to fight this in court. They eventually win because there is a legal presumption that this type of arrangement, meaning account holder adds an adult child to an account as a joint holder, is actually joint for convenience, for example, assisting with bill payments, and not for survivorship. So not with the intention that child will actually owns the assets in the account, more that they're there to help. So proper documentation in this case could have solved for this. So whether the dad's intention was or wasn't for his adult son on the joint holder to actually own the account on his death, proper documentation could easily have solved for that. The bank would understand the intentions, the executor would understand the intentions, and that could have been carried out accordingly. And litigation, of course, avoided, which who doesn't want to do that? Who doesn't want to avoid litigation? So something very easy that could have been put in place. Okay, final section of the case study portion of the webinar today. We're going to talk about some complexities that you might want to think about and whether they apply to you. So we're going to start off with a cottage property. Very often, although it's lovely to have a cottage, it can actually be quite a burden. It's a difficult asset to distribute upon your passing, depending on your situation, of course. In our case here, the owners have a lakefront cottage and they want to pass it down to their kids. They even go so far as to set aside funds in a trust for its maintenance, which is great because often we don't see that, and that can be a whole nother case study. But in this case, they've done that planning, which is wonderful. Unfortunately, when the time comes, though, only one of their three kids ever actually uses the property. The two other ones live farther away. They have older kids who don't visit anymore. And a big rift in the family develops, trying to figure out how to handle the property, what to do with it, making sure it's fair. Oftentimes, this can be one of the more significant assets in the estate. And without liquidating it, how do you even that out across family members? And so it's important to think about what there's what you want, but is that a realistic wish? And you can have a contingency plan, like I've mentioned before. So that's what your wish is. But let's think about the scenario where it's actually not appropriate at that time, and then what would you like to have happen? So you can kind of lay out, my wish is this, but if that doesn't make sense, then I'd like this to happen, instead of the family having to figure it out after you're gone. So some contingency planning here would have been very helpful. Left out kids. So often we see this where there's a second marriage and there's children from a prior marriage. And how do you properly plan for this and make sure that you're taking care of all of your loved ones? So in this case, the original couple has mirror wills that leave everything to each other, and then their children on the last to die. So mirror wills is basically they just say the exact same thing, and it depends on who dies first. But either way, the same thing will happen on the last to die. So in this case, the first spouse does die and everything goes to the surviving spouse. The survivor then subsequently remarries and makes a new mirror will with his new spouse. So that could be, for example, on the last to die, all the assets are divided amongst all of their children. Let's say they each had 2 children, it would be divided amongst all 4 children. But what happens in this case is he passes away, everything goes to his new spouse as per their wills, and then she updates her will and leaves nothing to his children from his prior marriage. So she's able to change her will. He's gone. Sadly, she decided to change his wishes. So there is an option there are actually several kind of things to consider and think about and strategies for this. One of the main ones, though, is a spousal trust, which basically means that your funds are held in a trust, outlined in your will, the terms of that trust and how you want it set up. But basically what it does is it cares for your spouse during their lifetime. But then once they pass away, it follows your wishes. So your spouse cannot change it. So it can then go to your children or all 4 children. If that's what you decide to do, the testator can make those terms up. And that's a good way of ensuring that your wishes are carried out and things aren't changed after you pass away. Charitable beneficiaries. So we touched on this in the first section, but we'll touch on it again from a different perspective here. So there can be additional kind of reporting requirements when there's charitable beneficiaries. So in this case, we have a physician who leaves a portion of his estate to several charities and the rest to his family. Because the charities are receiving a percentage of the estate, they're entitled to a full accounting. So what that means is a percent, let's say it's 50% of the estate. That 50%, the charities want to make sure that that's maximized. They want to get the most money from this will as they can. So they are, the executors are often under a microscope to make sure that everything is done in the interest of saving funds for the charities, which is fine. And the executor should do that. But there's a lot more formal reporting requirements involved. And this intense scrutiny of what they're doing can really become highly stressful. When you just have family members and everyone kind of just is in constant communication and they know what's happening, you can just provide them with a bank statement or keep them up to date with an email, versus a charity where it's much more formal and detailed. So this can be stressful on a family member executor, especially if they're not well suited to these additional complications. So knowing the additional work involved, if you are going to leave any percentage really of your estate to a charity, this may impact your decision on who your executor is. Might make sense to appoint someone who is able to take on these extra duties. Business interests. Okay, so lots of people owning their own businesses, incorporated, holding corporations, and it's really important to understand how to deal with these on death. I'm just going to take a moment here. So in this case study, we have a design consultant who has an incorporated business with significant wealth. No secondary will is done to avoid probate on the private company shares. Again, that secondary will comes into play here. Also, no considerations have been given to the additional complexities that will be involved in settling the estate. And one of the big ones being the potential for exposure to double taxation when that corporation is wound up. So, again, very important to know the strategies available to you, to make the process as smooth as possible, and to take advantage of things like avoiding double taxation. So again, very important to have someone who is specialized in this area that can really guide you. And same with the execution of the estate as well. Even a well-planned estate with something like a business takes a lot of extra special knowledge to make sure it executes properly. So something to think about there as well. Resident executors. So same with a business. As soon as we see a non-resident, a flag should go up that I need specialized advice here. And I need to think about what this means for my estate. So in this case, we have a widower who has 2 children, both live abroad, and she appoints them both as executor. So the court often waives an estate bond requirement. Like it's actually a requirement, but it's often waived if there are no non-resident executors. But as soon as we have a non-resident, they're far less likely to waive that. And this just adds significant time in arranging for the bond. It's an expense. And there's risk in that third party bond having to secure that. So it is an additional burden on those individuals who have to go through that process. And again, it can delay the estate settlement process as well. So if you have out of country executors, it's not that you can't appoint them, but it's recommended, or it helps a lot if you have a resident executor as well. So typically, as long as you have one resident executor, that bond will be waived. So nobody has to worry about that, because you have someone in the jurisdiction who's going to do the settlement. Transferring of investments. So we have, so we're looking at distributing assets in kind, which means not liquidating them, but basically keeping them invested and just transferring those into the name of somebody else. But a very common myth is that avoids tax. And in fact, it does not avoid tax. So in this case, we have a father who wishes for his kids to inherit and maintain his investments. There's lots of individuals out there who enjoy, managing their investments. He probably selected them carefully and had a reason for each one, and kind of wanted to maintain that. So to do that, he creates a will with very complex and highly specific instructions. But again, what he doesn't realize is that this actually means that there is no tax benefit to this. So one of the reasons he maybe was doing this was with that assumption that as long as I'm not liquidating, there won't be a tax implication. But there is. A death is a taxable event, and therefore there's a deemed disposition on death, which means that even if you don't liquidate those securities, they're transferred to somebody else. It's a taxable event. So there is no tax benefit, and probably these complicated instructions actually made things harder. Oftentimes when we see very detailed instructions, it can actually kind of limit what can be done. So careful to have the right level of detail and complexity in your instructions as well. So it could have been much simpler. He'd have to give up, obviously, his wish to have his investment portfolio maintained, but cash distributions are easier to divide amongst your beneficiaries. And what it does is it allows them to then create their own portfolio, or use that money for whatever makes sense for them at the time. Beneficiaries with disabilities. Okay, so again, another situation where knowing your options is really helpful. Here we have a couple who leaves their estate to their 2 daughters, one of whom has a disability. There was no specific planning done in consideration of that daughter's disability. So she received her inheritance directly, just like the other daughter. without any plan about how it could be accessed or who might help manage it. So as a result, her government benefits and support were jeopardized because she's now seen to have access to all this money, even if she can't actually access it because of her disability. She has it; it's in her name, so she doesn't qualify anymore for any government assistance. And there's also no ability to do any kind of tax efficient planning when the funds are just passed directly to her. So in this case, another situation where a trust is often a good solution. And there's actually a specific trust called a Henson Trust for those with disabilities. And they're set up so that their government support isn't jeopardized. So it's very tax efficient, and it ensures that individuals' needs are met over the years, so over their lifetime, without jeopardizing any support that they're receiving. So they can have the benefit of both. The government support can continue, but then they have access to additional funds through the trust to kind of supplement that government access without having it taken away. Foreign assets. So this is another very, very common one. And again, that word foreign, it just means that you've got additional complexities, you've got additional jurisdictions to deal with. So very common case, a Canadian snowbird passes away while owning real estate in BC and Florida. So very common, right? We see it often Florida or California, depending on where you live in Canada, Arizona. So there's a few places where we see a lot. Often properties are held by Canadian citizens. And in this case, they didn't do any specific planning for the US. And that's a big no-no. So we always want to see as soon as there's an asset in a different jurisdiction that's looked into, and the requirements for that area are considered and consulted, and the right documentation is put in place. So in this case, a local representative on the death, a local representative has to be arranged. The estate has to be probated in BC, and then it has to go through an ancillary probate in Florida. This can be so time consuming, like in terms of the time it takes to go through this process twice, and many months added, and legal expense added as well. You'll need to have like somebody in Florida that somebody has to find and arrange for it, because it wasn't done in the planning phase. So again, always adding complications, but proper planning can really alleviate this, and things can go smoothly. But without it, or with the wrong planning, without all the information, it can go horribly wrong. And so again, it's really good to have all the information, decide what's right for you, but make sure that you are considering those other jurisdictions and what needs to happen there in order for things to go smoothly, and how the two can work together. So you want to make sure too that, let's say you need to create a will in that jurisdiction, that the two wills work together. So it's always good too to have cohesive planning across jurisdictions. Okay, so that winds up the case study portion of the webinar, which is kind of the main portion of the webinar. So we'll just quickly run through some of the main takeaways that we're hoping that you got from today's presentation. I'm going to turn it back over to Ellie, and we're going to do the Q&A after this. So, I mean, why planning matters. Hopefully, this was all kind of clear in the case studies, but we'll review them again. So protecting your loved ones. So again, family harmony, whether there's discourse currently or not, whatever you can do to kind of maintain that harmony. Obviously, that's usually a very common wish, and lessening that burden. Again, it's enough to grieve a loved one without having to worry about learning a whole new area that you're not used to learning. Estate settlement, even if you know finance, it's a whole niche market, a specialized area of finance industry that not a lot of people are familiar with until they have to deal with it. So it can really add a lot to the executor's plate. Minimizing expenses. So lots can be done there. Probate savings, tax savings, lots of strategies available for that. Again, keeping in mind what the risks might be and whether it's the right fit for you. Protecting your assets, so maximizing the estate, tied to kind of minimizing expenses, of course, but making sure that you are setting your family up for success, and that very like your legacy, maximizing that for your family, for their future, and how you distribute that as well. So what makes sense for each beneficiary. The right representative. So we talked about this several times throughout the case studies, but understanding what those roles are. We didn't talk about POAs, that's powers of attorney, guardians, trustees. So there's a few different representative roles that may or may not apply, and each one kind of has its own unique duties and requirements. So it's good to think about each of those and who is the right person or people to appoint in those roles. Healthcare and last wishes. So part of estate planning is to make sure that you're kind of you're clarifying what your wishes are for your while you're living. So let's say you become incapable and you're not able to make your own healthcare decisions. You have a power of attorney for personal care, hopefully document in place that would outline who you'd like to take over that role. But you can also specify, you can get more specific with how you want them to care for you. So around last wishes and things, medical decisions and things like that. And then again, I think most importantly with all of this is back to that customization. So what are your wishes? What would you like to see happen? And of course, again, keeping in mind the family's circumstances and goals. And oftentimes it can be helpful to kind of document those main goals. And when you're going through the planning process, sometimes it makes sense to kind of revisit those, to kind of just go back a little, step back a little bit, look at the big picture, and it can kind of help guide when you're having to make these smaller decisions or more specific decisions. How does it tie back to my goals? So that can kind of be a strategy that people can use. Sometimes the planning process can be overwhelming. There's lots to think about, as you can see. And so we find that helps when people kind of feel kind of stuck with a certain decision. So that I'm going to wrap up my portion here. I will turn it back over to Ellie. I'm going to move us to the next slide here. So the best gift you can give your loved one is a planned estate. I can't emphasize that enough. Do what you can now to ensure that things go as smoothly as possible when the time comes. So Ellie, over to you.
Great. Thank you so much, Carrie. Yeah, definitely. The best gift you can give your loved one is a planned estate. We certainly live by that tenet here at ClearEstate. And I think hopefully some of these situations that Carrie went over might jog your memory a little bit about what you have currently in your estate plan or some of the goals that you're considering in your own estate plan. We are here at ClearEstate to help you. We want to be able to give you this amazing expertise that Carrie started to share with you today, so that you've considered everything from all angles for your unique situation. The way we do that is we make sure your wishes are clear and that they're going to be carried out quickly and efficiently. So there have been a lot of different scenarios we presented today where efficiency is not able to be achieved because a little bit of planning could have gone a long way. And so we certainly have the expertise here to make sure that your estate plan is going to be like dominoes cascading in a line. We've got everything set up ahead of time. We know exactly what to do so that you can leave the legacy you intend for your family. The way we do that is that you meet with us as an estate professional on Carrie's team, who's going to go over discovering what your goals are. So we want to talk to you first about what are the things that you want to achieve with your estate. We're going to intake your personal information, and that is typically your asset information. So there can be different places where we're going to raise up a hand and say, okay, you've got, property in the US. Let's talk about making sure that that's going to go smoothly in the future. We'll provide you with guidance and coaching about those decisions that you want to make to continue on this path towards the goal that we set out with you at the beginning. And then we develop a customized estate plan for you so that you get a visual representation of where your legacy is going to flow into the beneficiaries that you designate in your plan. And that is going to also include us drafting the documents for you. So here at ClearEstate, we're able to do that. We will create the will and power of attorney documents and other important documents that need to be part of your plan for you and get those over to you for notarization. After that, we can securely store them as well. It's important to always know where these documents are when it's time for them to be put to use. And we have a product for that called Clear Vault, where your estate plan is accessible to you at all times. You can always log in, have a look at it, and also see the documents that you have in place currently. So it's accessible to you. And in the future, it's an easy place to go for your loved one who's going to be settling your estate. We give you unlimited access to that. And the thing that makes us different is that we do an annual review. So, there are other options for planning your estate, definitely. I'm sure some of you have a great relationship with your lawyer that you've been going to for a long time. But as soon as you plan your estate with them, it immediately starts becoming outdated. And so we incorporate into our service an annual review. And that means we're going to check in with you once a year after we've gone through the process and say, here's your plan now. Has anything changed in your life? And those can be small or big things, but because we have built in and baked into our service an update feature, you can make a big or small change on an annual basis to your plan. And we will redraft your documents if necessary and make sure those wishes are incorporated. So that's how we do it. We have all kinds of experts here under one roof at ClearEstate. We're a team of 82 people now who focus solely on estate planning and estate settlement. Okay. So one of the things I think Carrie made really clear is that the estate settlement process, no matter how much planning you do, is still going to be work. There's going to be a lot of work involved. And so when you're thinking about who should your executor be, you may have someone in mind right now, but it's a good idea to consider a professional executor. And that is something that ClearEstate can do with you as well. So not only can we take you all the way through your estate planning process, produce your documents, but as a result of our annual updates with you, we're going to be perfectly positioned to also act as the executor for your estate and remove that burden from your family. It means that your estate is going to be settled more quickly because, again, it's all we do here at ClearEstate. We're purely focused on planning and settling estates. Typically, we're saving 3 to 6 months of time and reducing a lot of delays when it comes to settling your estate because we have planned it with you and we know how to execute when it's time. You're going to be working with the same professionals that you already do, and we'll introduce you to one additional expert here at ClearEstate who will be your person going forward that you will become accustomed to discussing your estate plans with. Our pricing is really something to consider as well. So other options that are out there are, big bank trusts or other professional executor services. And from our research, we know that they typically charge, at 4.5% on the first million of an estate. And it can be quite a significant portion of your legacy that you could be preserving. The fees here at ClearEstate, we have a setup fee. So that is going to include the redrafting of your wills and power of attorney documents or creation of them for the first time. That happens too with seniors. Okay. So yeah, we're talking about this dark blue column at the end. We have pricing for individuals or couples. And of course, we're going to make sure that couples' plans are closely reflecting each other according to their wishes. So the setup fee is what you see at the top in orange for an individual, in white for a couple. Then you see next the annual fees that are going to include the ability to update your plan on an annual basis. And then upon settlement, our fees are 1%. So remember, if you compare that to a bank trust, for example, they're starting at 4.5% of the value of your estate. Whereas ClearEstate, because we are so efficient and thorough in the way that we set up your estate plan, we're able to do this for 1% when the time comes. And for a couple, that's only after the second spouse passes. So that's our basic pricing. The first one I want to ask is just going kind of back to basics, which is, can you please clarify what exactly probate is and how are fees determined and who decides what they are?
No, that's a great question and very, very common question. So probate is it's a legal process, whereas it involves the court. Doesn't require a lawyer unless there's complications, but it is a legal process because the court is involved. And what happens is the court is basically kind of stamping the will as the official last will and testament of the deceased. And oftentimes, financial institutions will require this. It's required for most real estate transactions so that the person who is transferring the funds to the executor has that comfort that they're transferring those funds to the right person. So it is often required in Ontario, and the fees vary by jurisdiction. So in Ontario, I think a good portion of our viewers today are from Ontario. If you're not, it should be in your kind of legislation on your court website. But here it's 1.5% on everything over the first $50,000 of your estate. So they do kind of give you a little break on the first 50,000. There's also a small estate process where if your estate is under $150,000, it's a more simplified process, but the fees do still apply. And so it's often required. There's not a lot of cases where it's not, but again, back to the presentation today, there are ways that you can minimize those fees where it makes sense.
Definitely. And just to answer one question here, do we have representatives in British Columbia? Yes, we do. So we serve every province in Canada. We have specialists who have each their own areas and have memorized the probate fees in each province as well. So certainly we can help somebody who lives in any province in Canada. The question was specifically about BC. Yes, we have experts there. Here's an interesting question that I've seen before. It's about timeshares.
Mm-hmm.
Does that come up in planning quite often when you're working?
Yes, it does. And what I would recommend there is you'd really have to go back to the developer and inquire what that looks like, what your options are. Very likely it varies based on who that company is that is offering the timeshare, and whether there's kind of an agreement that you signed when you took on the timeshare. It might be there. So definitely something that is going to be specific to the individual timeshare.
Yeah, definitely something to consider when you're making your plan. The question was specifically, can it be willed back to the developer? So contact the developer and find out now, so that there is no question about what you need to do in the future.
Exactly. Yeah. And I mean, it's a great point to bring up, because like a cottage, do your beneficiaries want that timeshare, right? So thinking about that, it's great for you and you've loved it, but will your beneficiaries want that? So if the answer is no, then finding out now what's required and what the options are, it can be really, really helpful to know in advance. Yeah.
Here's a question about living estates. What is a living estate, and is there an advantage to having one? Does that mean creating a trust, like an inter vivos trust, perhaps?
That's what I'm thinking. Yeah. So there's two. So there's inter vivos trusts. I'll talk about those for a moment. So those are those are trusts that are created during your lifetime. And there's lots of reasons why that might be beneficial to you. But again, something that you need to discuss with your experts that you have in your toolkit, whether it's your accountant, or if you have an estate professional, or your finance person may be able to connect you with someone. But it's a living trust. You can put assets in there. It does offer kind of things like creditor protection. Your estate can be settled. Like assets in the trust won't form part of your estate. So those can be typically dealt with much quicker than assets in your estate. So there's lots of benefits to it. But definitely things to consider as well, because you need to do annual tax returns. So there's things that come along with that in those cases.
Yeah, speaking to an expert and getting some guidance if that's something you're considering is a really, really good idea. It'd be great to know more about why you're considering that, and probably there are other strategies to consider as well. So
absolutely.
Okay. If I'm named an executor of someone's estate, can I refuse or hire a professional executor?
Great question. So I think a lot of people maybe don't know this, but you don't have to assume the role of executor. So if you've been named and either you didn't know you were named, or at the time that you were named, you talked about it and you agreed because at the time it made sense, but now it doesn't. There is no obligation to accept that role. It's best to decide that up front as soon as possible before actually doing anything. And it's best to kind of walk away as soon as possible. Once you're down the road a little bit, it's a more involved process to be removed, and the court is involved once you've kind of been appointed. So it's important to take a little bit of time at the beginning and just make sure that it's the right choice for you. And if it's not, then you can renounce. So in terms of hiring a professional executor, if you are the appointed executor, what happens is there is an order, and it depends on the jurisdiction. So each province will have its own legislation, but there is an order with which people have entitlement to apply. So if let's say it's the spouse and they're not in a position to act as executor, like it then goes to the children, for example. And if the children aren't, or there's no children, then it goes to the parents. So there is an order. If nobody wants to act, or there's nobody available to act, then you can engage a professional. As long as everyone agrees and everyone that could take that role agrees, then yes, a professional can be appointed.
That is a service ClearEstate provides, and that would be the first step that we would go through, is making sure that no one else in the order of things is going to want to step forward to do it. So they all renounce, and then the professional can start the work. A question about probate. So I think this is about having liquidity in the estate in the future. So if executor does not get legal power to liquidate funds until probate is complete, how does the executor get the funds to pay for probate? Like, if there's like a cycle of questions going here, and it's all about, I think, ensuring that there's some liquidity in the estate.
Yes, absolutely. So these are great questions. Yes, so there's a couple of options. Oftentimes the bank, so if there's a bank account that that is in the name of the deceased, oftentimes the bank will allow funds to be accessed for certain things like probate fees, because they understand that it's required in order to get the document that they need in order to deal with the funds. So if you can present them with a will that names you as the executor, and you explain that you are applying for probate and that you need funds, they'll need to see proof from the court that this is the amount owing. But they will often, I don't want to say 100% of the time, but they should, because it's a legitimate estate expense. You can access funds from the bank often. There's another option to defer those if there's a really financial hardship. There's no access to funds. Maybe it's just really a real like a house, and there's not a lot of liquid assets. You can ask the court to have those deferred. So that's a process you can go through as well when you apply.
Here's an interesting one. How does the court know the will they're looking at is the last one? What if you made one at home?
So that's a great question. So I'm not myself familiar with the court's process, and I'm sure it varies. Again, the legislation, the processes, they all vary province to province. And I'm not familiar, to be honest, with the ins and outs of the court process itself and how they determine that. Some provinces have a registry and others don't. So unfortunately, I'm not actually able to answer that one. I don't know the ins and outs of their process, but
okay.
Yeah.
Usually it's going to be always advisable to have a will that has been notarized, and right, so that's going to make things a lot simpler for the court. I believe this person's in Ontario as well.
Yeah.
So.
And definitely to something to note, there's always make sure whoever you've named as your executor knows where your will is and that it is your last will. So we've seen it before where, someone's named like a trust company and that will sits in their what we call the will bank. And that person's now 106 years old. The family didn't know it existed and who to contact. So very important to do that.
Yeah. Okay. And then is the executor the same as a trustee?
So the terms are interchangeable. Executor actually in Ontario specifically is actually called estate trustee. It's a similar role. It's a fiduciary role. Executor is really specific to the estate, or estate trustee to the estate. And when that estate is settled, that role terminates. A trustee is basically someone who holds property. So again, an estate is often referred to as a trust, and therefore the trustee is the manager of the estate. But there's also the trusts, right? If you create a trust upon your death for a child, the person in charge of that trust will be called the trustee.
Okay. We have a few more. So wanting to use ClearEstate, especially as all our relatives that could potentially be executors live outside Canada in the USA. Hoping ClearEstate is familiar with US tax and final expense laws, as all our retirement and income comes from the USA, though we live here, moved to Canada post-retirement. So I think you went over that a bit, that yes, like with the right planning, and if you set up your estate, and ClearEstate is capable of this for sure, you can put in place what will need to happen in the future to get your estate settled if your assets are in the US. Is that correct?
Absolutely. That's correct. Yes. And we have the ability to deal with taxes on both the Canadian side and the US side on our tax team. So
yeah. Okay. The last three questions are all about probate and fees and how to apply for probate. So I would encourage you to have a look at our website. We actually have a checklist that you can download that's going to give you all of the answers, and you can think about your specific situation there. But ClearEstate's website does have information about a probate. We have a probate checklist. So yeah. I think that will help answer those questions.
And Ellie, do we have on our website too a probate calculator?
I believe we do. Yeah, so your jurisdiction will default on.
Perfect.
Yeah. So yes, we have a question from MJ Blackman. Last question. Internment. Does ClearEstate arrange for the internment in a cemetery, assuming plot is already paid for? So if you engage us as professional executor, we will have all of these wishes recorded for you. So that is something that we can take care of as well in the future, correct?
Correct. And I mean, something like this, that's a little more personal when it comes to kind of funeral arrangements and things like that. If we are the professional representative, then yes, we are responsible and we will definitely help to arrange, but it is nice or helpful to have a family member or family members who are involved in that as well. So they can do the more personal aspects of it. And we would work very closely with them to make sure that what we can do is done. But again, it's very helpful to have that. So in your last wishes or in your, if you work with us, we have a section where you can specify things about your funeral and your burial. And you can kind of specify there. We usually would deal, if there's no specifics, we usually would deal with kind of the next of kin with those more personal items.
I think that's just about time. We've already gone over time. Thank you, everyone, so much for those amazing questions. That was great. Carrie, thank you so much for a fantastic presentation. This was so informational. And Ellie, again, thank you to as well, because you were such a huge help here. And we just want to say again, thank you to everyone who attended.